Land acquisition and related issues. Proposed land issue has become increasingly controversial. It was because almost all opposition and coalition political parties opposed it. President signed the ordinance on the matter, but the proposal evoked very strong opposition in both the houses of parliament and in farmer community in general. Many social organizations also joined the protest. Government is finding it increasingly difficult to push the legislation, especially in the Rajya Sabha, where it is in minority. The Joint Committee of the Parliament is presently studying the matter. Now, before we go into the details of the controversy, let us understand why the government needs to acquire land. First of all, the land is a state subject, but the acquisition and requisition of property, which includes land as well, falls under the concurrent list, that is both central and state subject. In democratic societies, this power of compulsory acquisition is exercised eminently for a public purpose. The term public purpose is very wide in its connotation. Now, it can include privately executed projects also, but privately executed project should result in an indirect public good or some larger goods and services to the society. This land acquisition also could be towards increased tax revenue or for the employment. Many development projects require blocks of land and area is quite vast. However, any individual can stall the process of private market purchases. He may refuse to sell or demand a very unreasonable price, which is disproportionate to the market value. It may be that majority of owners are willing to sell, but one individual can stall the process. Now, further, in Indian conditions, land titles are often disputed, and there is a lot of confusion exists in the matter. A private purchaser gets no better title than the seller, and this discourages market transactions. When a land is acquired by government, the title defects are automatically cured by the statute and the allottee gets a clean title. Thus, the provisions for compulsory acquisition are essential to economic development. Now, every developmental project that is undertaken by the central government or state government has to be accompanied by a rehabilitation and a resettlement plan. That is under the rehabilitation and resettlement policy that is declared by the appropriate government. Now, people affected by land acquisition for the purpose of mining or hydroelectric projects are provided rehabilitation and resettlement package under this policy. And this is in accordance with the rehabilitation and resettlement policy of the states or the land acquiring agencies concerned, and there is a right to fair compensation and transparency in land acquisition, and it comes under the Rehabilitation and Resettlement Act of 2013. And it has made the rehabilitation and resettlement as a part of the land acquisition process itself. Under this act, that is Rehabilitation and Resettlement Act, the acquisition in the scheduled areas takes place only as a last resort. Rehabilitation and resettlement have been made part of the act as said before, and it ensures no displacement takes place for the people, and it will not be without adequate rehabilitation and resettlement package or a compensation. The collective rights of tribals are protected under this act, are supposed to be protected under this act, and there is a process of social impact assessment, and this is a part of the Resettlement Act itself. Now, why did the amendment arise in the land acquisition which has created such a controversy? Now, Resettlement Act was made mandatory for seeking consent of 70% of Gram Sabhas for the public-private participation projects and 80% for the private entities. This clause was seen as a major roadblock for acquiring land for the projects. In fact, this was an object of persistent complaints made by the industry as well as many state governments. Therefore, the proposed Land Acquisition Act sought to make amendments in the law, and it was expected to balance national development requirements. And there was a need to compensate landowners and questioned the states who were opposing the changes. Now, the existing Act, Section 105, had kept 13 most frequently used acts for land acquisition for the central government projects out of the purview. These acts were applicable for national highways, metro rail, atomic energy projects, electricity-related projects, etc. Therefore, large percentage of farmers and affected families were denied the compensation and rehabilitation and resettlement measures as prescribed under this Resettlement Act. Therefore, the present amendments propose to bring all those exempted 13 acts also under the purview of this Act, and it was for the purpose of compensation as well as rehabilitation and resettlement. Therefore, according to the government, the amendment benefited the farmers and the affected families, which was not at all accepted by the opposition parties. And the government argued that the process of land acquisition is a prolonged procedure, and as a result neither the farmer is able to get a benefit nor the project was completed in time for the benefit of society at large. Therefore, Modi government took the land acquisition as a matter of priority and passed an ordinance in 2014, and it subsequently extended it in May 2015 for the third time. And it expired sometime in August, and thereafter the government, looking at the opposition for the proposed legislation, did not pursue the act in the Lok Sabha or Rajya Sabha. Land acquisition and rehabilitation and resettlement. Now let us see what aspects are involved in land acquisition, rehabilitation and resettlement. Now this was an ordinance in 2014 which sought to amend the Resettlement Act, which received President assent on December 2014. The ordinance amended Section 10A of the Act, and it expanded the list of projects that would not require social impact assessment and also prior consent of the affected families. And these projects included the defense and defense production, rural infrastructure including rural electrification, then the affordable housing and housing projects for the poor, industrial corridor as well as infrastructure and social infrastructure projects were also covered in this, and it included a public-private partnership projects as well. However, the ownership continued to vest with the government in these projects. As per the changes brought in the ordinance, multi-crop irrigated land could also be acquired for these purposes. The earlier act provided for a consent of 70% of landowners whose land was acquired for public-private projects. The ordinance also changed the definition of compensation paid from an amount deposited in the court, as defined by the Supreme Court, to any amount paid into any account maintained for the purpose. Now, it also expanded the scope of infrastructure to include private hospitals and educational institutions, which were left out in the original act. The original act defined infrastructure projects for which the land could be acquired, and it said it excluded private hospitals, private educational institutions and private hotels. The ordinance also replaced the term private company with private entity. This means in the amended ordinance, private purposes could be for any private entity and not necessarily a private company which was statutorily registered under the Companies Act. Now, there were criticisms, as said before, and lots of opposition by almost all the opposition parties as well as the farming community. Now, criticisms were on the amendments to the Land Acquisition Act on the grounds that, number one, the Land Acquisition Act of 2014 made the land acquisition process consultative and participatory. Further, it made the land loser a stakeholder in the project, and the land acquisition for private companies required a consent of 80% of affected families. Therefore, there was a scope for reducing a misuse of the law for private purpose. Moreover, it made the rehabilitation and resettlement of the project affected a legal right. Now, it has been criticized that the real factors holding up projects are not being addressed by the proposed act. Instead, the government had chosen to simply scrap several progressive features of the original act. Now, the second criticism, the ordinance subverts the crucial distinction between public versus private purposes. The criticism was that the ordinance widened the scope of private purpose acquisitions, and therefore it was subject to misuse. Further, the ordinance also scrapped the requirement of social impact assessment studies for several categories of projects. So this prevented the consultative and participative nature of the acquisition process as it was there in the original Land Acquisition Act. The social impact assessment is vital for ensuring that the land acquisition is in a social interest. It is because the potential social benefits from the project are much more than the cost to the acquisition affected people. Now let us see what is social impact assessment in this context. The impacts of development projects occur in different forms. Now, significant benefits result to the society, but the project area people may often bear the brunt of adverse impacts. This can happen, for example, when they are forced to relocate and make way for such interventions. For example, the hydroelectric project. Now, there is now growing concern over the fate of the displaced people that is felt much more than before. This has given rise to the need to understand beforehand itself the implications of adverse project impacts. And the idea was that the mitigation plans could be put in place in advance itself. The worst example was in the case of Narmada River project in the recent years and many industrial projects in the earlier years. And these impacts were not only in terms of the social impact of displacement, but also of recently environmental concerns as well. And as we all know, the environmental groups, environmental awareness has increased in the society at large. Now, the National Rehabilitation and Resettlement Policy, which was issued in 2007, recognized the need to carry out social impact assessment, and it was as a part of the resettlement planning and implementation process. And the opposition parties pointed out that this social impact assessment was excluded in the proposed land acquisition amendments. This social impact assessment policy underlined the need in the case of a new project or expansion of an existing project, and it involved involuntary displacement of 400 or more families. Now, social impact assessment alerted the planners as to the likely benefits and also costs of the proposed project, and as said before, its impact could be social and economic. The most useful outcome of the social impact assessment was to develop mitigation plans, and it was to overcome the potential negative impacts on individuals and communities. Now, advantages of doing social impact assessment was very clear, therefore, in this background. And to be specific, the advantages were social impact assessment helped in identifying people and the groups and also who were affected by the project. The cause and effect and the people affected were very well defined in this social impact studies. Now, the second advantage was the social impact assessment could help to clear the fears of affected groups and further build a basis of trust and cooperation, which was so essential for successful project implementation. Now, social impact assessment also provided the basis for preparing mitigation measures, and these mitigation measures were to avoid, reduce and manage adverse impacts. Now, social impact assessment preparation also helped to identify the measures to maximize and share the project benefits all over. Now, addressing social impacts at an early stage helped to avoid costly errors in the coming times. A well-prepared social impact assessment demonstrated that the social impacts are taken seriously, and it helped in getting a project clearance faster. Now, to conclude, it remained to be seen as to how the government managed to incorporate good measure in the new legislation and remove the adverse clauses and convince all the political parties, social groups and farmers in general